Yes, but the reason why, my lord, will see that almost all of the authorities that I've referred at paragraph 19 are in the immigration context is because there was at least at some point a tendency to set aside the fact-finding tribunal's decision simply on the basis of disagreements or simply on the basis that facts were not fully set out. And the courts have made it absolutely clear, including the Supreme Court, that judicial restraint must be exercised. So when Lords and Milady considers the first ground, and in order to decide whether the First Tier Tribunal made an error of law, I'll respectfully invite the court to apply these principles and then assess the reasons given by the upper tribunal for interfering with the first judge's decision.
The essence of your point is your paragraph 20, really, isn't it?
Yes.
They may have been generous, but that's not the issue.
That's not the issue, yes. Now, if I may then just take you to the three decisions made below, just to make the submission good. Now, may I take you first of all to the Secretary of State's deprivation decision. Miller and Friend relies on it heavily, says that, well, it's clear enough what the Secretary of State was seeking to say. But can I take you to that decision? It's in the core bundle, page 178. This is right at the end of the last
this is the
document,
decision
core bundle.
matter.
Yes.
Yeah.
Now, if you look at, you'll see that there is, the Secretary of State sets out the background of the case and the criminal proceedings. So paragraph 8 and paragraph 9, the Secretary of State sets out the offense and notes that the offense as to the possession of criminal property, the offense started from 1st of January 2010 and ended on 5th of March 2012. The Secretary of State at paragraph 11 refers to an answer given by the appellant in the application form. We take no to the question about the character. And then paragraphs 12 and 13 are really the heart of this decision. But what is, in my submission, immediately clear is that the Secretary of State is not expressly alleging dishonesty in completion of the application form. So the Secretary of State refers to the criminal offense, refers to the answer given by the appellant, but does not say expressly that that answer was dishonest. Now, the appellant surely ticked no to the relevant question. If he is dishonest, the Secretary of State had the power to deprive him of British citizenship. If he wasn't dishonest in answering that question, there is no power to deprive him of British citizenship. So nowhere in this decision, dishonesty is alleged by the Secretary of State. Now, the appellant appealed, saying that, well, he wasn't dishonest. Can I show you only one ground of appeal, and I'll then take you to the upper tribunal's decision. If you look at page 175 of the bundle, these are the grounds of appeal to the First Tier Tribunal. For the present purpose, may I ask Lords and Milady to look at paragraph 36 and paragraph 37, which is on the next page. So the appellant says that my involvement in the criminal conduct is not determinative. The issue is whether I am dishonest when I completed my application form. The focus must be on my state of mind. The Secretary of State bears the burden of proof. The Secretary of State must prove that, well, I was dishonest, that the grant was motivated, dishonesty motivated the grant of citizenship. So that's what the appellant said. Now, the matter then reached the First Tier Tribunal. And may I take you to that decision now, page 131 of the bundle.
Pleading Mr. Malik, can I just ask you this? Suppose that the Secretary of State's decision letter had said, in terms, we believe that you lied when you filled in the form
Yes.
because you must have known what you were up to.
Yes.
Would that have made a difference to the position in terms of your points about procedural fairness?
No. I mean, for the reasons that I will come to in due course, the answer is no. It makes no difference. But I thought I would show you the decision just to make the point that even taking at its highest as to what was happening, the Secretary of State wasn't alleging deception, at least expressly in the decision letter.
Your position is that it turns upon what happened before the First Tier Tribunal.
Precisely, yes. That's the point. But in response, my learned friend says that, well, look at the decision. The Secretary of State was clearly alleging fraud. The appellant knew what was the issue, so no issue with that. But that is the decision. I've shown you the ground on which the appellant appealed. May I now then show you the upper tribunal, the First Tier Tribunal's decision, and just to make very brief submissions on a rather frustrating procedural history and what the Secretary of State did. Now, if you look at the first page, you will see that the Secretary of State was represented.
Yeah.
If you look at paragraphs 9 and 10, the judge knows really well what the decision letter says, and he knows, this is paragraph 10, that the criminal conduct was from 1st of January 2010 to 5th of March 2012. He knows that. The learned friend would ask you to accept that the judge ignored that completely. He knows that. But then what the judge said under the heading procedural history is quite remarkable. Now, when the Secretary of State is served with a notice of appeal and bundle, the tribunal issues a standard directions. The rules require the Secretary of State to review the matter, file certain documents. That wasn't done. So the matter was put before a judge, Judge Karbani. This is paragraph 14. The judge looked at, so the appellant filed the bundle at paragraph 13. Judge Karbani then looked at the matter, looked at the skeleton, looked at the submissions, and then issued directions that, well, we need to know what the Secretary of State's position is. He hasn't complied with the directions. And if there is no response, then there may well be a presumption that the respondent takes no issue with the submissions made in the skeleton argument. That direction was ignored completely. The case was then called on before another judge, Judge O'Garrow. This is paragraph 16. He looked at the matter, and there was then a further request to the respondent to review the documents, the witness statements, the skeleton. Judge noted that there was a failure to comply with the directions and gave further directions. So this is the second judge who asked the Secretary of State to set out the position. The response with respect is truly staggering. This is paragraph 17. Now, I drafted that skeleton that was referred in that response at paragraph 17. The Secretary of State says that, well, the skeleton argument is not good enough so to warrant a response. So two judges looked at that skeleton, two separate judges. They were happy with it. They asked the Secretary of State to provide a response. And this is what she says, that the skeleton fails to specify and clearly define the issues. Well, I can't respond. Now the matter was then came before another judge. This is the third judge who's looking at it, Judge Adiyu. This is paragraph 18. So this was a full hearing converted into a CMR because of the failure to comply with the directions. The judge then again looked at the skeleton and said that, well, these are the issues. And then quite remarkably, you'll see that the Secretary of State gave an undertaking to file a skeleton, to file a response to the appeal skeleton. This is paragraph 19. She breached that undertaking, failed to file a skeleton or any response to my skeleton or the grounds where the appellant was saying, well, focus on my state of mind, I'm innocent, you haven't really alleged deception or discharged the burden of proof, how can you deprive me of British citizenship? So paragraph 20, no review was provided to the
So is the upshot that you turned up in front of Judge Latter and there was no skeleton argument from the Secretary of State?
No review, no skeleton argument, zero engagement with the point that was being made, that the appellant is not dishonest. The Secretary of State, at no point, the Secretary of State had at least 4 opportunities prior to that hearing to clearly allege dishonesty on part of the appellant, to say that you are dishonest when you completed the application form. That wasn't done. So the matter reached before Judge Latter. Paragraph 21, so 4 missed opportunities. Secretary of State says, well, I'm sorry, we haven't complied with any of the directions. No application for adjournment, no application for further time to review or to file a skeleton or to set out the position. And I invited the judge, this is paragraph 23, to say that, well, this is quite a serious matter. The Secretary of State is depriving a person of British citizenship, the most draconian step the state can take against a person. Significant time has passed. Proceed with the hearing. There's no adjournment application by the Secretary of State. The judge proceeded with the hearing. Now, and then you'll see the heading, the hearing. So this was the 5th opportunity for the Secretary of State, 5th opportunity to allege deception, to say to the appellant that you are dishonest, 5th opportunity. So he gives evidence. Paragraph 27, he was asked, well, why is it that you ticked no to the question about the British citizenship when you were engaged in questionable criminal activities? He said that I ticked no because I honestly believed that was the true answer. He was cross-examined, but not challenged on that point.
Yeah.
The cross-examination is at paragraph 28. It was all about the offending. The Secretary of State at that point was shooting the wrong target. The appellant said that he had no knowledge of what was happening, that it was a criminal property. Now, his lack of knowledge was not a defense in the criminal proceedings. A mere suspicion, as Lewison says quite rightly, is enough. But he was saying that, well, I had no knowledge. And the answer is true. And that account was not challenged by the Secretary of State. Then there were closing submissions. Now, if you look at paragraph 33, you'll see that that the Secretary of State submitted that, well, there was a criminal activity.
Well, 32 is maybe of some significance, because what Mr. Lum is submitting is that your client must have put forward his account of being unaware of the actions and not have been believed, but in fact he pleaded guilty.
Yeah. So no.
So it wasn't a question of his saying all this to a jury and being disbelieved. He pleaded guilty.
Absolutely. Again, in my respectful submission, the Secretary of State was shooting the wrong target. There is no power to deprive a person of British citizenship on the basis that he has committed a crime or on the basis that he is not of good character. The Secretary of State can only deprive a person of British citizenship in this context if the citizenship was obtained by fraud, by dishonesty.
Yeah.
So true it is that he was convicted of a criminal offense. True it is that he must have been aware or at least suspicious that the property was a criminal property. That is not the question in this appeal, as I pointed out in my grounds and in skeleton argument and at all earlier stages. The question is whether when the appellant completed the application form, what was his state of mind, whether he was dishonest or not. And this is paragraphs 32 and 33. The Secretary of State says that, well, he must have been aware of that, and despite that, he ticked no. Now, I made 3 separate submissions in response. Now, it is, in my submission, important, significant to note that there were three distinct arguments, and if the court keeps that in mind, then in my submission, it would be easier to follow the reasoning of the judge. If you look at paragraph 36, to support this position, Mr. Malik put forward three distinct arguments, and the judge dealt with those three arguments in turn. Now, I need not to take the court's time on the first argument, at least. So at this point, the first argument was a complaint about unfairness in the decision-making process. But we can park that to one side for a minute. If you go to the second argument, this is paragraph 30.
Yeah.
And I said that, well, the Secretary of State was conflating the two separate issues. Commission of crimes is not determinative. The point that was made in the grounds, in the skeleton, the question was whether the answer was dishonest. Paragraph 39, the submission that I've just made, there's no power to revoke citizenship on the basis of criminal conduct. And then paragraph 40, that there's no challenge in cross-examination to the witness.
And you were making this point, as I understand it, in your closing submissions
Yes.
to Judge Latter.
Yes.
And Mr. Lum didn't at that point say, well, I'd like to recall Mr. Ullah and ask him some questions.
No. And I add this, my lord, given that you've asked the question, that these are the points that I made in my original grounds of appeal.
Yes, indeed.
And in my skeleton. And three judges asked the Secretary of State to look at those documents, respond. She failed to respond. So it's not simply a question. My lord is absolutely right that the Secretary of State made no request to the judge to recall the witness. But these were not the points that I was seeking to make for the first time in my closing submissions. These were the points that I made in my original grounds. So the evidence was not challenged. So that is the second point. This is paragraphs 38 to 40. The second distinct point, that's enough. That was enough for the judge to allow the appeal. And you then have the third point. This was the alternative point that I made, that, well, in any event, the Secretary of State bears the burden of proving that there was criminal conduct before 2012, and there is insufficient evidence to prove that. So that was an alternative third submission that I made. And then paragraph 42 reminded the judge that the appellant is not required to show that he is innocent. The burden of proof is on the Secretary of State. She must prove that the appellant was dishonest. Now, if you then go to page 137, the next page, you'll see a heading, the evidence.
Yeah.
The judge says that he is having regard to all the documents, including the Home Office bundle, which included the indictment, the sentencing remarks, the decision. So when you look at the reasoning of the judge in order to decide whether the reasons are inadequate, you consider the fact that earlier on in the decision, paragraphs 9 and 10, he expressly acknowledged the timing of the criminal conduct, and then he expressly takes into account everything that is being said by the Secretary of State in the documents. The judge then directs himself properly as to the law, sets out the relevant statutory provision. If you look at paragraph 48, he identifies the presidential guidance in BA. Now, I'll not take you to that decision, but you'll see that it sets out a step-by-step approach that the fact-finding tribunal should take. The first question is whether the precedent fact is established, namely the Secretary of State has established that the appellant was dishonest. Paragraphs 49 to 52, the judge directs himself properly as to the standard of proof. Civil standard of proof, the burden is on the Secretary of State. It's quite a serious issue. And what the appellant is required to do is to put forward an explanation. And the Secretary of State has the burden of proving that that explanation is to be rejected. This is all well known, Shazar and Chaudhry, paragraph 52. So when a person puts forward an explanation, the Secretary of State has the burden of disproving it. So how can you disprove? How can you invite the tribunal to reject an explanation without challenging it in cross-examination or at any point. So you then look at findings and reasons.
But you accept the explanation has to be plausible.
Of course, absolutely, yes. But no issue here that the explanation was plausible.
No, I mean, it's not absolute. It's not just an explanation. There is a threshold.
Yes. So, again, given that my lord has asked the question, there is some case law on the subject. So, what by plausible, what is meant is that the explanation must be capable of belief. It must not be hopeless.
Yes.
Accept that, of course. Yes. But no one is suggesting here that
No.
the appellant's explanation was hopeless, was so hopeless that it was incapable of
it's
belief.
not. I mean, the reason I asked that is not said that the explanation didn't call for cross-examination or a challenge to the explanation that was given.
Absolutely, yes. Now you then look at findings and reasons. So by that time, again, I apologize for repeating myself. So no express allegation of deception anywhere in the decision or in response or at the hearing in cross-examination. You then look at the findings and reasons. The judge again directs himself properly as to the law, makes it quite clear that dishonesty is the touchstone, and
That's in
absent.
paragraph 61.
Yes.
Yeah.
So 60 and 61. 60 is the Secretary of State's ongoing. There's no dispute about it. Now, if you then look at paragraph 63,
Yeah.
the judge says that, well, I accept the evidence as credible. Now, when the judge made that finding, the judge had in mind the appellant's evidence, the fact that the criminal conduct was from 2010 to 2012, the judge expressly referred to that, and the judge had in mind all the documents in the Home Office's bundle, which he expressly took into account, found that the appellant was a credible witness. The judge then sets out the reasons, refers again to the fact that the burden of proof is on the Secretary of State, and then at 65 says that, well, his evidence was not challenged in cross-examination. So paragraph 66, instead of challenging the question, instead of challenging that point, the Secretary of State was focused on commission of a criminal offence in line with the decision, but that surely is not enough. Paragraph 67, the judge records the submission that, well, even if the judge accepts everything that is being said by the Secretary of State, that there was a criminal offence, the timing was from 2010 to 2012, that does not mean that the appellant was dishonest when he completed the application form. Paragraph 68, the judge agreed with that submission, took into account the established factual background, and makes the finding that you'll see there. So that was enough in my submission for the judge to allow the appeal. The judge then, from paragraph 69 onwards, in my submission is dealing with the third point that I made, that, well, in any event, where is the evidence of criminal conduct or the knowledge of it prior to the date in question? So paragraph 69, the judge says that the conviction does not establish that the appellant knew of the activity at the time of making his decision. Now, there is some criticism by the upper tribunal, by my learned friend, as to that alternative reasoning, but the reason in my submission is entirely correct. The conviction does not establish knowledge. As the court knows well, mere suspicion of criminal property is enough. So we don't know whether the conviction was because of the knowledge or because of the suspicion. the appellant gave evidence that he did not know that before the judge. The judge accepted that. So 2 points. Firstly, this is an alternative finding, and secondly, the finding is entirely correct. The judge then at paragraph 70 says that, well, even if the appellant was aware of the activity, and he then makes the point that that really isn't the question. The question is about his state of mind, whether he had intention to deceive the Secretary of State when he completed the application form. Paragraph 71, deception must have motivated the grant of citizenship, a phrase from the case law. And the judge then says that, well, it has not been established that the appellant completed his application for British nationality with a deliberate intention to deceive. Now, this is a finding of fact that was open to the judge on the evidence, open to the judge to find that on hearing from a witness who wasn't challenged at that point, and to whom it wasn't put at any stage that he was dishonest. The judge then essentially allows the appeal on that basis. So I do say that the findings made by the judge were open to the judge. The reasons are adequate. He wasn't required to identify and engage with every single document in the respondent's bundle. He dealt with the main primary issue, and the fact that he has made a decision which the Secretary of State is not happy with isn't a reason to interfere with it. Now, the Secretary of State then appeals to the upper tribunal from this decision, and she appeals on a single ground. If I may take you to page 127 of the bundle.
Well, she's got two grounds, I think. Gone behind the findings of the criminal court and failed to apply the second part of the argument. Grounds.
Yes. Yeah. Yes. But they were essentially two sides of the same coin. But if my lord takes that would take that as two grounds, I have no issue with that. So page 127 of the bundle. So the first year judge, the Secretary of State says, goes beyond the findings as to when these offences took place. But when I showed you the first year's decision, I showed you paragraphs 9 and 10. The judge expressly recorded that the offending took place between 2010 to 2012. I wasn't inviting the judge to go beyond the findings made by the criminal court. The judge did no such thing. But linked to that finding was that, but the second point linked to that is that that the judge has failed to provide adequate reasons for the finding, that the appellant has provided an innocent explanation, and that is then linked with Ivy. So the real ground is inadequacy of reasons. And when the court would judge the adequacy of the reasons given by the First Tier Tribunal in the procedural context that I've sought to highlight in my opening, and in the light of the authorities to which I've taken you to in my submission, my lords and my lady will come to the conclusion that there was no error of law in the judge's decision. May I then take you to the upper tribunal's error of law decision, just to show you what it said when it interfered with the Secretary of State, when it interfered with the findings of fact made below. So this is page 110 of the bundle.
Yeah.
Now, if you look at paragraphs 5 and 6, the upper tribunal sets out the offending and the period of the offending. The first judge has also expressly referred to that in the decision. Now, if you then go to page 114, you'll see a heading conclusions on error of law. and if you look at paragraphs 26 and 27, you'll see that the relevant provisions from the 2002 Act, the Procedures of Crime Act, are set out. Paragraph 27 in particular. So lack of knowledge is not a defense. If the offender knows or suspects that there is criminal property, then that's enough. So the upper tribunal rightly points out that there wasn't a Newton hearing. There was a guilty plea. So no issue is taken. No issue is taken as to the guilty plea. If you then look at the next page, page 116, and that really is the heart of the upper tribunal's decision. The judge failed to engage with, or at least provide adequate reasons in respect of, not simply the fact of the conviction, but the obvious implications of that conviction. Now, the judge expressly engaged with the fact of the conviction and the implications of it. He recorded expressly that criminal conduct, paragraphs 9 and 10 of the first judge's decision, that the criminal conduct took place between 2010 and 2012. And then the upper tribunal says that, well, that is highly relevant to his state of mind. I entirely accept that. But the upper tribunal can only interfere with the first judge's decision if there is an error of law. Relevant, surely the background is. But the question for this court is whether that is something that was taken into account by the judge. If it was taken into account by the judge, the weight to be given to it was a question for that judge. It is not suggested by the upper tribunal that the first judge failed to take that into account. So if you fail to take into account a relevant factor or a material matter, that makes the decision perverse. That is not the complaint.
No, they might have said in paragraph 31 that the decision was perverse, but they didn't. They're saying wasn't adequately reasoned.
Yes, they could have said that the decision was perverse. If they had said that, I would have said that it's not perverse for a judge to make a decision that seems to be generous. But given that Lord has asked the question, and so perversity was not a ground on which the Secretary of State challenged the decision. The upper tribunal did not interfere with it on that basis. It interfered with it on the basis that there was a failure to engage or provide reasons in respect of the background. There was clear engagement. There was clear reasoning.
I think it's paragraph 69 of the First Tier Tribunal's judgment where they say that these facts, taken at their highest, do not establish the appellant knew of the activity at the time of making his application. So what they're essentially saying is, although it might get you 90% of the way, it doesn't inevitably follow that there was dishonesty when the application form was filled in as a matter of logic or as a matter of evidence. And that's and that seems to be ignored in paragraph 31 of the upper tribunal.
Yes.
You can go so far with the evidence, and you say it may be generous,
Yes.
but unless it's coterminous
Absolutely.
with dishonesty, you say that proposition, that evidence which was given before the FTT by Mr. Ullah had to be challenged.
Absolutely.
Because it's that 10%, it's that incremental gap which was critical to the outcome.
There may be cases, there may be some cases where an acceptance of the criminal offence necessarily involves that you knew you were engaged in something criminal before you filled in the application form.
Yes.
But here you've got a plea of guilty,
Yes.
which is consistent with a lack of actual knowledge and suspicion. No Newton hearing, so you don't know which way it goes. He then gives his explanation.
Yes. Now, Milady is absolutely right. Now, when I took the court of the First Tier Tribunal's decision, I was focusing on the paragraphs that are directly relevant. But Milady is absolutely right that there are those sort of cases. The first judge acknowledged that those cases were referred as the clear-cut cases.
Yeah.
So where, for example, a person lies about his identity.
Yeah, or yes, an offence of dishonesty at first instance in front of the Crown Court, which is either found by a jury in particular, when the jury says we're sure he
Yes.
was dishonest,
Yes.
the inference which the Home Office could then put to the First Tier Tribunal that there was dishonesty may be overwhelming,
Absolutely.
but this wasn't an offence of dishonesty,
No.
so there was a gap.
Absolutely. So a sort of typical example, and that is an example that the first judge gave, where a person lies about his own identity, says that he's from X country, but he's actually from Y country, gets indefinite leave to remain, applies for citizenship on a false identity. That's enough, a clear-cut case, but not this case, surely.
So it's got to be, what is the reasonable inference that can be drawn from the admitted facts? Can you inevitably conclude that it involves an element of dishonesty?
Yes.
If yes, it maybe we're in a different situation.
Absolutely.
But if no, then there is a gap which needs to be filled. Here it was filled, maybe generous, maybe improbable, but it wasn't challenged.
Absolutely. Lord is absolutely right. But can I just add on the point that completely agreeing with my lord, that the Secretary of State had every opportunity to say that there wasn't a gap.
We see that.
Or you know the point, right? And it wasn't even suggested by her. And then
I mean, part of, as my lady has said, part of the key to your submission is that the offence only requires suspicion.
absolutely.
I mean, if your client had been convicted of robbery, for instance,
Yes.
and failed to disclose it, he could hardly say that he didn't think that was a crime.
There is, yes. Now there are examples of a judgment from this court, a case called Eddie Doyen, which established the principle that, well, dishonesty is the touchstone. In that case, there was a criminal conviction. The appellant knew about that, yet took no to a question whether there were any criminal convictions. His appeal was allowed. The court said that even in that extreme case, the fact-finding tribunal must assess the person's state of mind when he completes the application form, and then decide whether he was dishonest. So robbery is an extreme example, and I couldn't disagree with that. But if, for instance, someone has a driving offense, that is a criminal offense, but that person may nevertheless honestly believe that although it is an offense, it's not serious enough to warrant a disclosure. If he honestly holds that belief, he's not dishonest, and that really is the task of the first year fact-finding tribunal. So the reasons,
Spent convictions are another example, aren't they?
yes,
Spent convictions, he might
spent
tick the
convictions,
box.
precisely, yes, or convictions abroad. There are cases on that. Now, then paragraph 32. So the judge says that, well, there is no proper analysis or adequate reasons. They say that, well, there wasn't any evidential gap. That's a misreading of the first judge's decision. The knowledge is not enough. And in my submission, the upper tribunal essentially misunderstood what the first judge said by gap. So the gap wasn't in the gap of the knowledge or the fact that there wasn't a crime. The gap was that, well, that does not in itself demonstrate that the appellant was dishonest. So these really are the two paragraphs, and the.
So you say paragraph 32 is simply wrong. The conviction and the relevant documentation do not speak for themselves. They go to a different question.
Yes, but it is. Yes, in my submission, it's difficult to understand what the upper tribunal was seeking to do at paragraph 32, because the paragraph starts. The ground is that there aren't adequate reasons, but these are points where the upper tribunal just analyzes the matter again, and in my submission disagrees with that.
It's muddled because if you look at the sentence, in terms of the second, the mens rea went to the issue of knowledge, although of course mere suspicion was a sufficient. I read that as the upper tribunal saying, well, because he pleaded guilty, he must have known,
Yes.
because there was no Newton hearing and there was no complaint about his solicitor's advice or anything at the
Yes.
time. Ergo, he must have known rather than suspected, and that's just muddled.
Precisely, entirely
Completely
inconsistent.
muddled thinking.
Absolutely. And the ultimate conclusion is at paragraph 34, the judge erred by failing to give adequate reasons. So that is the ground on which the first judge's decision was set aside. The IB point was essentially linked with.
Sorry, just one moment.
Yeah. Shall we do that? To the Sorry, Mr. Molly.
Yes. And the IB point, the upper tribunal said, was essentially linked with the reasons challenge. Well, in my submission, what is clear is that the upper tribunal was just not happy.
Yeah.
Was just not happy with the first judge's decision, felt that it was a generous decision or a wrong decision,
Yes.
and decided to interfere with it on that basis.
Or being generous to them, they thought it was a clear-cut case when it obviously wasn't.
Yes, precisely. But I do also say that, although I need not to make this submission, that the decision, the first judge's decision, wasn't a generous decision. It's difficult to see what else this judge could have done when the Secretary of State did not allege deception in the decision, failed at 5 different occasions to.
And the evidence
forward
wasn't
the case.
challenged. The
The
evidence
evidence
wasn't
wasn't
challenged
challenged.
in cross-examination.
Yes.
Yeah.
Now, Milan Friend has put forward a respondent's notice, making 2 points. The first point is that I'm somehow asking the court that the appellant is trying to go beyond the conclusion of the criminal proceedings, and this is an abuse of process, and the sections 18 of the 1968 Act applies. But I'm not doing any such thing. I'm not
No,
asking.
you're maintaining the position that the facts of the conviction does not show that your client was dishonest in completing the form.
No, precisely. So I'm not seeking to impugn what has happened in the criminal proceedings. The second point that Milan Friend makes is that, well, the first judge's decision is perverse and irrational. Now,
Not open.
no, not open to the judge. There are 2 short points that I make about it. The first point is that it is not open to the Secretary of State to make that point
That's
for the
what I
first time in this court. If there ever is a case where it would be appropriate to deny the Secretary of State an opportunity to reformulate the case, this is that case. 5 opportunities below were not taken up. When the first judge allowed the appeal, the Secretary of State decided not to challenge that decision on perversity grounds. The reason why I showed you sections 11 and 12 of the 2007 Act, although fairly well known, is that when a party wishes to challenge the decision made by the first judge, you can only challenge it if you seek permission from the first tier or the upper tier. It would have been another thing if the Secretary of State had appealed on perversity grounds at the upper tribunal. The upper tribunal had not allowed the appeal on that grounds. The Secretary of State could then have put in a respondent's notice asking the court to allow the appeal on that basis. But to say that the decision is perverse for the first time by way of a respondent's notice is simply not the way. But in any event, for the reasons that I have developed already, this isn't a case where dishonesty is inevitable. Milan Friend can only succeed
Yeah.
if she shows that there is no room for a different outcome. There surely is. Just one final point. Malone Friend has referred in her skeleton argument to two documents: the booklet, the guidance on completing the application form, and the booklet that accompanied the naturalization application form. You have those documents in the supplementary bundle. Just want to emphasize that those documents were not in evidence before the First Tier Tribunal. The Secretary of State had not relied on those documents below. I accept that those documents were put before the upper tribunal, and the upper tribunal formally admitted them, but the upper tribunal did not rely on those documents to set aside the First Tier Tribunal's decision. If it had said so, I would have been making an argument that the Ladd and Marshall test is not met, and you cannot impugn the findings of fact on the basis of fresh evidence. But in any event, if Malone Friend takes you to those documents, you'll see that those are simply documents accompanying the application form, explaining how one should complete the form. They do not demonstrate that the appellant was dishonest. I mean, in a sort of paradigm case, the Secretary of State could have taken
Court ready? Court rise if able.
Mr. Mallings, is there anything you'd like to add on ground one in the light of Toohey and Griffiths?
I'm very, very grateful to my lord and the court. Well, the paragraphs that my lord highlighted plainly support the proposition that I was seeking to advance. But very grateful for this. It's a timely reminder that I need to look at the authorities in areas that I do not specialize in.
Often helps.
Yeah, absolutely. So my submission is that the approach set out by the Supreme Court applies in principle to this jurisdiction with equal cogency.
It's a civil law case,
yes,
but in a public law context where procedural fairness is all the more important, one might assume it applies a fortiori.
yes,
And in any event, the civil burden of proof applies to determination of dishonesty in the tribunal, doesn't it?
absolutely. Very good. Thank you.
Yes, Miss Reeves.
Yes, my lord. I don't know how best to assist you. Do you want me to deal with Toohey first, or shall I just make my submissions on?
Make your submissions on Mr. Malek's ground one in
One.
whatever order you think fit.
I'm grateful, thank you. In the first instance, my learned friend took you very properly through sections 11 and 12 of the Tribunals and Court and Enforcement Act 2007. I don't need to take you to those, but I just want to state what I hope is an uncontroversial proposition, that in terms of an error of law can include a failure to have regard to material considerations. It can include inadequate reasons. So, and that is very much what I say the upper tribunal found in its error of law decision, and there was no error of law in the upper tribunal finding that for reasons that I will develop. Now, my learned friend took you to the deprivation decision, but he didn't take you to a key paragraph. So if I may please, the decision starts at page 178 of the core bundle. And the relevant part that I wanted to take you to that you weren't taken to is paragraph 10. 10. So paragraph 10 is the paragraph after which sets out the criminal offending, and then it sets out the period of offending about halfway through, and then describes very clearly that you lodged your application for British citizenship on the 27th of June 2012, which means you had been involved in criminal acts prior to applying for British citizenship. And that is relevant, I say, to the way in which the Secretary of State put a case before the First Tier Tribunal. I'll obviously come to that in a moment. But when you read this decision in the round, it very clearly does make the point in my submission that this is all about dishonesty in the completion of the application for naturalisation in circumstances where he had been involved and convicted of an offence which predated that application. You get it from paragraph 10, you get it from the other paragraphs, but you certainly get it from paragraph 19. Just stay over the page, which very clearly refers to
19, did you say?
paragraph 19, my lord.
That's about the appeal.
It is, but it refers to the relevant section of the British
Oh, I see.
Nationality Act under which the deprivation is happening, and
Yes.
that's 43. That is all about dishonesty. There's 3 different gateways, but
Yes.
they're all about dishonesty.
The problem is that if one looks at paragraph 12, for example, the last sentence, you wouldn't have been deemed a good character in view of your activities with the immigration crime group. So that's basically saying the fact that you have committed the offence is enough for us to find that you're not of good character. And that's nothing to do with what he's put on the form.
My lady, I accept that the decision letter could have been better worded, but it's my point when you take it all together in the context that paragraph 11 is dealing all about question and answer to 312. And 312, have you been engaged in any other activities which might, and I'm going to place some emphasis on might when I get to the relevant decisions, but indicate that you may not be considered a person of good character. So that is the focus. It's not the focus that you've got the criminal conviction as such. It's in the context that you fill out your answer to that question with no. So I say if you, the holistic reading of the decision is that it's squarely about dishonesty in the application form, and that's why we're in 43, the British Nationality Act.
It might be said that all the more important that there was proper engagement with that issue before the tribunal. And it doesn't cry out, I understand the point, it doesn't cry out that this is essentially an issue of dishonesty at its very essence. And, well, we all know these things happen with unfortunate regularity, but there wasn't proper engagement with the issue before the tribunal, and the tribunal wanted it.
I acknowledge that. I've obviously heard what my learned friend has said about the 5 opportunities, but they took the 5th one, and they took it at the hearing, and ultimately...
Well, that's the point, did they?
Yeah.
Well, I will say they did, and that's obviously my the journey I've got to go on to try and persuade you to come with me, but they did for reasons that I will explain, and I'll address when I get to there, obviously to Ian Griffiths. Now, if we go, please, to the First Tier Tribunal decision. And I'd just like to take you, please, starting off at paragraph 26, because you've been taken through this decision at some length very properly by my learned friend. And this is a telling question and answer, because he was asked 2 questions by my learned friend. The first is whether he had committed any crime before the 18th of September 2012, and he answered, no, I didn't. Well, that's patently incredulous in circumstances where he has a conviction for money laundering, and he pleaded guilty to it, and he hadn't challenged the basis of the plea in a Newton hearing, and, as the upper tribunal recorded, had made no complaint about the legal advice received at any point during the criminal proceedings, and yet further still, had not appealed against his conviction. And it's in that context that I make my submissions. Now, my learned friend, the nub of his submission is that, well, he then asked the appellant if his answer to question 3.12 on the naturalisation form about why he ticked no, and the answer was, well, it's the honest answer. And my learned friend, there was discussion about whether or not this called for a challenge in cross-examination. And in my submission, it didn't. And it is one of the examples, and I'll take you to 2 in a moment, of it being simply incredulous in the circumstances of the conviction and the other factors that I've just referred to, and I won't repeat them, the lack of Newton, lack of appeal, etc. And it'd probably be an opportune moment to go to Ian Griffiths. And obviously, there's very helpful.
What's the significance of the lack of a Newton hearing?
Well,
Why is that of significance?
because well, for example, he hasn't sought to say, well, I'm pleading guilty solely on a suspicion, not on a, because there's 2 limbs to the mens rea. I'm afraid I'm not a criminal lawyer. I don't know what significance
That's it,
that
but,
would make.
well, it would make a great deal. You have a Newton hearing if the prosecution take issue with the basis of your plea, or if your plea is tendered on a particular basis.
Yes.
But you don't have to have one if the if you don't have one, then you would be sentenced for the offence on the basis of the lowest form of commission of the offence. And so he would have been sentenced, no doubt, on the basis that he suspected rather than that he knew. And so the absence of a Newton hearing, to my mind, certainly is a complete red herring here. Certainly a Newton hearing wouldn't actually make any difference in terms of sentence unless the judge had heard him on a hearing and disbelieved him, which might have made a great deal of difference generally.
There's a difference between, in terms of dishonesty, between suspecting and knowledge. So if he'd been sentenced on the basis explicitly he knew there was criminality, then that might be more relevant to dishonesty. If he's sentenced on the basis he suspected there could be dishonesty, that might also be relevant and more in his favour when it comes to dishonesty. So when he went into the box and said no, and it said that he was dishonest, there is a difference between the different mens rea in the offence and the basis upon which it would have proceeded on a plea in the Crown Court. But if he'd gone to the jury and the jury had convicted him, they may well have convicted him on the basis of a case which was actual knowledge.
But for the purposes, even if it is a red herring, to use my lady's words, suspicion, the mens rea of suspicion in the context of deprivation under 43 is sufficient in my submission, and that's the basis upon which you can read and should read the way in which the Secretary of State put a case below.
Then you've got to say that, let's assume, because we're having to speculate a little bit and fill in gaps, let's assume he was, that it was suspicion, and when he filled in the box no, it was because he only suspected and he didn't think that was dishonest on the basis of the facts, that he didn't know why the money was in his account and so on and so forth. You might say that's pretty rum stuff, but at the end of the day he went into the box, he said he didn't think he was dishonest. There is that bit of daylight. It's not inevitably the case that suspecting something means that you are subjectively dishonest when you fill in the form, and that's the bit he wasn't cross-examined.
And moreover, you've got to think about the timing. The form is filled in before he's even arrested, before he gets any legal advice. If his legal advisors say, actually, sorry, if you thought there was something iffy about this money coming into your bank account, you're still guilty. That's something he knows later. But at the time that he's actually filling in this form, all that he knows is that at most there's something dodgy about the money that's gone into his account.
Well, in which case, that would still be something that should have been in the form.
Well, that depends. But let's assume that's yes. Then the question is, was it dishonest not to put it down? And that's when he said, well, I didn't think it was dishonest at the time. And you may be incredulous at that. But the question is, was it something that had to be tested in court? And if not, was it wrong for the FTT judge to conclude that in the absence of a test, I should accept it?
Well, in my submission, it wasn't such to call for cross-examination, and the absence of cross-examination.
That's got to be the point, hasn't it?
It is, and I'm not shying away from that, and that is how I'm putting it to you. And to that extent, in relation to the Supreme Court's judgment, if I can just pick it up from paragraph 60, please. There's obviously analysis before about the need in circumstances to challenge evidence, but it's at paragraph 60 where I wanted to pick it up. It talks about, 61, that there's a long established rule with which practising barristers would be familiar, and there are also circumstances in which the rule may not apply. Can I just make 2 points on this? The first is that I can see that there may be an argument that actually that rule should also apply in the first tier in the upper tribunal. I haven't had time to consider if there's an argument that it wouldn't. Of course, there are no strict rules of evidence in the first tier tribunal or upper tribunal. I don't seem to argue that that means a different standard of fairness applies.
This is about fairness, it's not about
I don't, but I would say this, that there is an argument that the rule might be more flexible in that context. But I do so in this way. What the judgment recognises is, although there's a rule, there are some exceptions, and then the judgment goes on to list them.
Yes.
I've looked at them, and in my submission, and where I put my client's case is in paragraph 62. And that is that where the evidence of fact may be manifest incredible, which is why I made the submissions in the way I did before, an opportunity to explain on cross-examination would make no difference. I've obviously heard the observations that have been made, but I maintain the submission for the reasons that I've already given, that it is and was incredulous. And that's the way in which the Secretary of State put her case below. And one can see that, my lords and ladies, from the submission that was put on behalf of the Secretary of State. If I can take you, please, to paragraph 66.
66.
66 of the judgment, please, at page 141.
Yeah.
So, Judge Latimer records the fact that Mr. Lum had focused his cross-examination on the fact that the appellant had been convicted of a criminal offence, but, and this is where I rely on, it was his submission that the conviction related to activity prior to the completion of his application for British nationality, and therefore he must have known that he was not of good character.
Well, it's the therefore that's the problem, isn't it?
Well, that's the gap, so-called.
I mean, what Mr. Lum was saying, apparently wrongly, at paragraph 32, was that Mr. Ullah must have put forward his account of being unaware of the actions of others and not have been believed, but he didn't. He pleaded guilty.
Yes, I mean, but that doesn't fatally infect, in my submission, the overarching submission that he made, that because of the criminality, where the mens rea included the knowledge or suspicion, and the suspicion was enough, and to conceal that you had that suspicion, which he did, is enough for the purposes of section 43.
That makes it worse for you, not better. Suspicion, that's the problem. There's a bigger gap between the mere suspicion and dishonesty and awareness in 32. I mean, it's quite a technical point of criminal law, but it's quite important.
I appreciate that, but I don't. But also,
and Mr. Lum repeats that in 33. That Mr. Ullah must have been aware of the criminal activity. That doesn't follow at all.
No, and I understand, because it would be said, well, actually, that's a submission that you must have had knowledge. You had the mens rea of knowledge, and that wasn't put. But I say we're in the incredulous realm of evidence, and it wasn't obliged to put. I don't think repeating myself, I don't think is going to assist me.
I think your strongest point with respect is the fact that he's caught out in an obvious lie about not knowing or that he didn't commit a criminal offence at all, which was the first point you put to us. So what you've got is him saying in answer to Mr. Malik initially, did you commit a criminal offence before that date? To say no, which is obviously wrong since he's pleaded guilty to it, that colours every other answer that comes. So I can well see an argument that faced with that obvious lie, anything else that he says about it should be taken with a very hefty pinch of salt. But whether that actually takes you across the bridge far enough to say, well, it obviates the necessity for cross-examination on the point, I'm not so sure.
Well, I mean, that is, my lady, and I was going to come to it, so I'm glad you have now. That is obviously how the Secretary of State put her grounds of appeal at page 127. In paragraph 1, that essentially the First Tier Tribunal has gone behind the criminal court findings of when these offences took place. But it does go on to say that the tribunal failed to provide adequate reasons for finding that the appellant has provided an innocent explanation, and therefore accepting his denial that he committed a crime before the 18th of September 2012.
But that wasn't the point, was it? That wasn't the point. The point was he dishonest in filling in the form?
No, but it's the foundation of the point that it infects the credulity of the
Yeah.
rest of his evidence,
And
therefore the
I
point
mean,
that
going back to Tuohy for a moment,
Yes.
in the summary of principle, Lord Hodges' summary of principle at paragraph 70,
70, yes.
he emphasises in sub-paragraph 6 that the opportunity to explain in cross-examination is particularly important when the opposing party intends to accuse the witness of dishonesty. So that's the Secretary of State's case, was that Mr. Ullah was dishonest, which elevates the importance of cross-examination.
Yes, I mean, there clearly was cross-examination. We don't have a I accept he wasn't cross-examined on the points in paragraph 26, well, 27, I have to accept that. But in my submission, it certainly appears that he was cross-examined on his credibility in the round, and that's how I put the case. Can I just turn my back for one moment, please? If there's
Yes.
anything? In my submission, I rely also on what I've said in the skeleton argument on ground one, but I don't think it's going to assist me to take you through them. You've read them, but for all of those reasons, I maintain there was no error of law, or the upper tribunal wasn't wrong to find an error of law in the First Tier Tribunal's decision. I don't know if there's anything further I can assist you on ground one.
Thank you very much, Ms. Reeves. Mr. Malik, do you want to reply on this ground?
Just two very short points, if I may. So my learned friend took the court to paragraph 26 of the First Tier Tribunal's decision, and that really is the point that Milady picked, that was an obvious lie when the appellant said that he did not commit any crimes. Okay, can I just say this? In reply, that the appellant's answer to that question was then not probed in cross-examination, and in my submission, the answer, it's quite clear, was not a no in a technical sense. It was no in a practical sense. So what he was saying was that, well, he had no knowledge of the crime. And that's how, in my submission, he understood that question. See paragraph 28 in particular. So when he was asked questions about the criminal convictions, that's what he said. So it wasn't, in my respectful submission, a lie. I mean, the presenting officer could have said, well, you are lying, aren't you? Look at your indictment, your criminal convictions. He then could have said, well, could have said that, well, this is what I actually meant. But in any event, that paragraph 26, plays no material part in the actual analysis of the judge.
Well, the judge doesn't actually go on and say anything about it. He doesn't make a finding that he didn't commit a criminal offence, which is the way that one reads the Secretary of State's original appeal.
Yes.
The suggestion that there was this finding that he didn't commit a criminal offence, which there never was.
Court rise if able.
Mr. Malik, we need not hear your other grounds of appeal. We are going to allow appeal and reinstate the decision of the FTT for reasons to be given later in writing.
I'm very grateful, Lord. Very grateful. Thank you.
Is there anything else we need to deal with today?
No. So once the draft judgment is circulated in the usual way, Bill and friend and I will agree on a draft order,
Yes.
including on consequentials.
Right. All right. Thank you very much.
Court rise if able.
Shame we didn't get to have some big